My name is Ruth Zachrin, and I am the CEO of the Massachusetts Coalition to Prevent Gun Violence. I'm excited to be with all of you on this rainy Thursday. Thank you for joining us for today's Lunch and Learn. I will get us started in just a moment, but before we do, just a couple of housekeeping issues. We are recording this meeting, as you may have noticed from the announcement. This is something that we do want to have to share with others who are not able to attend today. So just want to let folks know in case you don't want to be on camera. We are also going to be we're going to have our friends from Giffords share some information, some prepared questions, and some time at the end for everyone to ask questions of the presenters. And I would just encourage folks to be entering their questions in the chat as we go along. We will get to them at the end, but feel free to fill up the chat with anything that you want to talk about, and we'll be looking at that towards the end of the presentation today. And without further ado, I want to start by introducing my friend David Pucino, who is joining us from Giffords. David is the Legal Director and Deputy Chief Counsel. And very importantly, he has been a great friend to the coalition over the years. We've done a ton of work together, particularly around the passage of the omnibus legislation that we saw signed into law this past July. We really deeply appreciate our relationship with Giffords and with David, and we're really excited to welcome him today to share some information about a policy that we are working on this session, which is industry accountability. David is going to be sharing with us some information about what that policy is about to frame the issue and give us some background information. We will then be welcoming Joe Platt, who's someone else from Giffords that we do a ton of work with, at the end of that presentation. And they will be available for questions that I've prepared to start with, and then we will open up to the rest of the group after that. So David, I would love to welcome you to get started.
Thank you so much, Ruth. It's such a pleasure to be here with you all today and to be able to continue the fantastic work that we've done with the coalition over the years. It's a true pleasure. So I have some slides prepared that I'm going to share and look forward to the question portion at the end of the conversation. But if anything comes up from a technical standpoint or otherwise, you can't hear me, whatever, please do stop me as we're going. So the topic today, as Ruth said, is firearm industry accountability. And in particular, what is one of the most cutting edge legislative strategies that bridges the kinds of gaps in the law to allow for the gun industry and its worst actors to be held accountable and to allow for survivors of gun violence to have access to justice through our courts. In our work, we often think of changing the law as being a legislative strategy. Just based on the way that we approach this issue and our advocacy, that tends to be the frame that we have. But litigation has, throughout American history, been another critically important tool for accomplishing policy change. It is one of the key drivers of accountability and justice in our legal system. They are essential and at the heart of driving change alongside legislative change. And the volume of litigation that takes place every year, from small matters to large matters, has the power to make change in ways that sometimes legislation can't. It will incentivize companies to innovate, to make their products safer. And for companies that don't do that innovation and don't make their products safer, they have a competitive disadvantage. So it encourages self-policing. It encourages companies to be proactive about public safety. It encourages them to look ahead at what risks they might take on. And so as a way of having industry writ large internalize some of the costs of what they're doing, think about what the impact they're doing might be on the community, and to do that not just out of the goodness of their heart, but because they know that the threat of litigation out there for misconduct, for bad actions, for failure to act in the safest way and the way in the best interest of the public can be financially ruinous in some cases to them. The externality of doing harm to the public becomes internalized through the process of litigation, and that discourages irresponsible behavior. It discourages illegal behavior. It discourages companies from acting irresponsibly. And at the same time, it compensates those who are harmed by that misconduct. And so in a range of areas throughout American history, but in particular in the modern legal era, litigation has been a critical tool for policy change, specifically when companies were causing harm to the public. So we saw that with the tobacco litigation. We saw it very recently with the opioid litigation, but we've seen it with things like asbestos and with car safety. In each of these instances, we had an industry that was performing an important function, had been behaving irresponsibly, had been causing harm to the public, and the public suffered significant harm, sometimes catastrophic harm, and litigation drove the industry to solve the problem, and it compensated the people who have been harmed in the process. This process does not work with the gun industry, and it's for a number of reasons. But as a result, we have an industry that is on the whole reluctant to make the kinds of innovations and improvements that would promote public safety. But even more than that, it allows for an environment where there's a race to the bottom. In most industries, if you're going to be on the cutting edge of safety, that's a competitive advantage because it means that litigation risk is lower. And those bad actors who are hanging out in the back, who are not making those innovations, who are not behaving responsibly, who are breaking the law, are going to have that risk of litigation potentially driving them out of business altogether. And that process is essential for a healthy environment, for a healthy industry, and for public safety. But because we don't have that accountability in the gun industry, because we have barriers to getting access to justice, we don't have that mechanism in place. And so what we have is a very small number of gun companies that are disproportionately driving gun violence. Folks generally talk about the 80-20 rule. 80% of consequences can be attributed to 20% of causes. In this space, it is 90% of crime guns are coming from 5% of gun dealers. That's a statistic from our friends at Brady. So the gun industry is at the far extreme where a very small number of wrongdoers are causing a great deal of harm. But the number of structural and legal barriers made it hard to go after those 5% of wrongdoers. There are a few different reasons for this. One is that the victims of gun violence are very often under-resourced and don't have the access to litigation, don't have the access to lawyers, don't have the kind of capital, social capital, and financial capital to be able to mount really successful litigation strategies against the gun industry. And that's a major, major barrier. It's hard for somebody who is a survivor of gun violence, who's lost a loved one, to get a lawyer to bring the case for them. Far more than in something like a simple slip and fall case. That path is much easier than to bring a case in a gun violence scenario. There are also barriers to accessing key information. The gun industry has lobbied very hard at the federal level and also at the state level to block the release of information that would implicate gun companies in misconduct and connect gun companies to shootings. So things like the TR amendment at the federal level that prevents the sharing of tracing data, the ways in which the industry makes it very difficult to gain access to those records, the prohibitions against digitizing any records. All of these things are done to prevent that information from being available. So even if you're able to get a counsel, even if you get a lawyer who can bring this case for you, is willing to look into it, well, where do they look? How do they figure out where the gun that shot you came from? Oftentimes that information is simply not available. And those kinds of barriers are really a huge problem in this space. And the third issue I'm going to talk about here, and probably the most significant one, is a federal immunity statute called the Protection of Lawful Commerce and Arms Act that has really shut down a lot of litigation in this space and been a huge boon to the worst actors in the gun industry. So this statute was signed into law in the mid-2000s during the Bush administration, and it essentially created a powerful tool that the gun industry can use to shut down litigation early in the process, an enormous procedural hurdle to bringing any case against a gun company. It takes the standard legal principles that we apply to companies and to people alike for accountability and takes them off the table. The baseline standard of when you should be held liable for your actions does not apply to the gun industry because of this statute. And as a result, the small number of irresponsible gun companies who are disproportionately responsible for the harm to the public get protection. They get this legal barrier that anyone bringing a case against them has to surmount first. So you've gotten your lawyer, you somehow got the information, you know how the gun that shot you was sourced. You now, in bringing this case, if you were bringing a case against a grocery store where you slipped and fell, you bring the case, the grocery store might say you have a legal theory or not, you argue it out in court. Before you can even get to those questions, you have to surmount this federal statute if the defendant is a gun company. If the way you were injured was not from slipping and falling on the floor, but being shot by a firearm, you have additional legal barriers you have to go through just to get your case heard in court. And that promotes a race to the bottom because every irresponsible gun company knows that they have this hurdle in place. So they know that they have additional protection. So if they engage in misconduct, they're not likely to be held accountable. It's going to be very expensive for a plaintiff to hold them accountable. So that encourages that unaccountable behavior, that encourages that bad behavior, because you can make a sale that might be illegal, but if you're not caught, you made the sale. The sale is the sale. And so responsible companies who are not going to engage in that illegal conduct, are not going to lower their standards, don't get to make those sales. So the bad companies make more sales. The bad companies are more profitable. And that's a huge problem. It's a huge problem because those bad companies should not be in business. They should be put out of business. And civil liability would be a mechanism to do it. But even more than that, it encourages companies that might be on the borderline to say, well, I see this other guy over here. He's breaking the law. Why do I have to follow it? And in conversations I've had with ATF inspectors, the people who are responsible for going out to gun dealers and noting their violations of regulatory and statutory law, going out there and saying, you're doing this thing you shouldn't be doing. You're not conducting your background checks right. You're not retaining your paperwork right. They say that the dealers always get so frustrated with them when they're told you did your paperwork wrong, because they say, well, there's other guys out here I know who aren't even doing what I'm doing. Like, I do my best to try to do this paperwork, and yeah, I don't really care about it that much. I do a pretty crappy job. But there are people out there who aren't doing the paperwork at all, who are selling guns off the books. That's the kind of environment we're working in, where the worst actors are people who are ignoring the law altogether because they think that they won't get caught. Importantly, critically importantly, this immunity statute is not total protection. It does not say you cannot sue the gun industry at all. It makes it harder, but it does not make it impossible. And in particular, it does not apply when those who are bringing the lawsuit can show that the company they're suing, the gun company, intentionally broke the law or knowingly broke the law. So in the case where you have somebody who is breaking federal law or state law, they do not get this immunity protection. They do not have the ability to shut down your lawsuit. Now you have to go through this first step. That's still a problem, but they can't close the door in your face. This exception is called the predicate exception. So what that means, to break down some of the legalese here, you have this federal immunity statute, which is the Protection of Lawful Commerce in Arms Act, that usually gets pronounced as PLACA, although I've been hearing PLICA a bit recently, but PLACA generally says lawsuits against companies that make or sell guns where the harm suffered was because of criminal or unlawful misuse of the gun by someone other than the gun company cannot be brought against the companies. So company A sells guns, person B is hurt by guns. If the way that person B was hurt was because a third party, C, misused the gun, so Bob's Guns, Acme Guns sells a gun, let's say, to use my ABC, Bob is hurt, Charlie did the shooting. That's the pattern where usually you wouldn't be able to go and sue Acme Guns. But if Acme knowingly violated a state or federal law applicable to the sale or marketing of the product, of the gun, and the violation was the proximate cause of the harm, we're within what's called the predicate exception. Predicate meaning you can point to a prior violation of the law that allows for your lawsuit to go forward. So if Acme didn't conduct a background check when they sold the gun to Charlie, you can sue Acme because Charlie wouldn't have had the gun except for the fact that Acme sold it to him without the background check. That would allow you to bring the case as Bob. PLACA does not protect unlawful conduct, is the bottom line of this. Because this law was constructed only in the first place to be the protection of lawful Commerce in Arms Act, so unlawful conduct is not protected. What that also means is that the states have tremendous ability to set the terms under which guns are sold in their state, because this exception applies to violations of federal law and state law alike. So states have the ability to say, in our state, these are the rules you have to follow to sell guns. And if you don't follow them, you can be sued. And nothing in the federal immunity statute would block that, because the statute is designed to allow for states to set their own terms of gun transactions. And so in the past 4 years, we've seen peer states to Massachusetts pass legislation similar to the legislation we're talking about today that sets clear terms under which guns can be sold within the state. We'll get into the exact terms of exactly what those statutes look like right now. But the key thing I want to highlight with this slide is that in all of the places that do the most to prevent gun violence, we're seeing these laws signed into law and being used to hold the gun industry accountable. So we can make sure that survivors have their day in court, that families who have lost one to gun violence have an avenue to get redress, compensation. I mean, nothing can ever make a person whole again, but the financial compensation available is the best that we can do. And that can be something that's available to them and often isn't now. And more than that, we can stop gun companies from breaking the law. We could stop it because anyone seeing this lawsuit will see that that kind of misconduct is something that is punished on the bottom line. And therefore, when they're doing their calculations, when they're determining their risk and cost benefits, when they're trying to decide whether to do the right thing or not, they have the financial incentive to do so. So this is the key legislation. This is the legislation here today that we're talking about. And I want to run through a few of the key elements. This bill would establish for anybody selling guns, you have to have reasonable controls and reasonable procedures to prevent unlawful gun sales. You have to have a process in place that's reasonably calculated to make sure that you're not doing illegal things. So you need to give some high-level examples, non-exhaustive examples. You need to train your employees to know how to identify an unlawful sale. Two people walk into a gun dealer. One of them points at 6 guns on the wall and hands cash to the other person. The second person goes up and says, I want to buy those 6 guns, gives you the cash and tries to do the background check. That's a straw sale. You cannot make that sale. That's an illegal sale. But you need to train your person operating the register on how to do that. And if you don't do that, you should be held accountable for an unlawful sale. You have to take reasonable steps to prevent those illegal sales and to prevent gun trafficking. If you got a guy coming in every week, he's buying 10 guns, same model. He goes out to the parking lot, chats with the guy in the parking lot, comes back in next week, does the same thing. You've got to take some steps to prevent unlawful trafficking. You can't promote illegal use of guns. You can't target minors in your advertising. I'm sure everyone remembers the JR-15 from a couple of years ago. It was a 22 caliber rifle that was designed to look like an AR-15. It was expressly marketed to children. You can have an AR just like your parents. Can't target minors. And you have to generally comply with the law. So you can't break any of the other laws that are on the books. You can't act with impunity. And that sounds like an obvious thing. Why would you need to say you can't comply with the law? But the gun companies right now argue that they don't have to comply with the kinds of laws that everybody else has to comply with. They argue that because of the Protection of Lawful Commerce and Arms Act, they don't have to deal with the kinds of consumer protection regulations that every other business in the state of Massachusetts and across the country has to comply with. So this says no, you have to comply with the law. Every law, you have to comply with it. If it's something that applies to products being sold in the state of Massachusetts, it applies to you. The goal of this legislation is to do all those things I just mentioned, and it's to do it through the vehicle of allowing lawsuits against a small number of bad actors. So the legislation would empower the Attorney General and survivors of gun violence to bring actions in court against those bad companies. It creates a distinct cause of action. So you wouldn't have to go into court saying there's negligence here. That would be blocked by PLACA. You wouldn't have to identify a violation of the Consumer Protection Statute. This says if you've been harmed because of gun violence, you have the right to sue. You sue under the statute. It's all consolidated together in one piece. It gives a clear path, even for a lawyer who's never done a case like this before, about how you bring a case against the gun company to get relief for survivors. That relief can take the form of money damages, compensation for the harm that you've suffered. It also can include the form of instructions to the defendant about things they need to do to make sure that never happens again. You need to do training for your employees. You need to have video recording in your parking lot. If somebody's coming in and buying 10 guns a week, you need to report that to the authorities, those sorts of things. The statute also, critically importantly, and something that I think doesn't normally get highlighted, it covers the attorney's fees for bringing a case like this. It covers the filing fees, and it covers the other reasonable costs of bringing litigation. So all of those barriers, those structural barriers that prevent under-resourced people who are overwhelmingly the victims of gun violence from bringing cases are going to be covered under the statute. Your attorney's fees are going to be covered. The cost of putting in those filings are going to be covered. The cost of doing all the investigative work you need to be able to develop this case, all those things are going to be covered so that you can get the relief you need. You have an access to justice that would otherwise be denied to you, either under the strict legal terms of the Protection of Lawful Commerce and Arms Act, or under the practical terms of all these structural barriers that prevent people from being able to access the court system. These laws, as I've said, have been passed in states beginning in New York 4 years ago, and now coming up to about 10 states. These cases, so a number of cases have been brought under these statutes now, and I want to give kind of a highlight of what some of those cases look like. Let's say that some folks who are prohibited from possessing guns decide they want to get some. They want to find some guns so that they can resell them. They go on Google and are looking around at gun dealers around their state. And they look at some pictures. And they see one gun dealer that has pictures of all of their guns stacked beside a glass window without any reinforcement, protection bars, anything. They can see this just on Google. So they go to that gun dealer. They figure out which window it is. They smash the window. They grab the guns out. They take them. And they sell them onto the street. And in the years since, cops continue to find these guns at crime scenes. That's a real case that happened in New Jersey. And this law allowed the New Jersey Attorney General to sue that gun dealer to say, you need to take some modicum of basic steps, common sense steps. You can't leave your inventory by an easily accessible window overnight. Seems basic, seems like it's something that should never have happened, but because of the irresponsibility of that gun dealer, there are dozens of crime guns on the street in New Jersey that there wouldn't otherwise have been. Another example, this one's also from New Jersey. You have a state that passes a strong ghost gun law. And so ghost gun companies that have been selling directly into the state stop doing that. Instead, they redouble their efforts to sell in a bordering state. And they do all those sales knowing that those guns go up to your state, that come into your state. And in some ways, they design their practices to make it easier. They run gun shows that are really accessible in that area. So they're supplying ghost guns to your state, even though your state has passed a law to prohibit ghost guns. That's something that happened in New Jersey after they passed their ghost gun law. Ghost gun companies were operating in Pennsylvania, knowing these guns were going up into New Jersey. And because of this statute, the state of New Jersey had an avenue to go after that ghost gun company. And they brought a lawsuit, again, in New Jersey. Another example here. Radicalized white supremacist is bent on carrying out a mass shooting. He wants to use an assault weapon to do it. But he's in a state that has an assault weapons law. He goes into a gun dealer and says, I'm really looking to buy an assault weapon. And the dealer says, well, I can't sell you an assault weapon. Those are illegal. But if you take this gun that I have here and you take this lock off of it that fixes its magazine in place, you have a detachable magazine. So now you can swap out your magazine and you can have an assault weapon. The radicalized white supremacist takes this weapon and then goes to Tops Friendly Markets in East Buffalo, New York, and kills a dozen people in one of the worst racist mass shootings in our history. That gun dealer should never have sold that gun to this person, should certainly not have told him how to circumvent the law. And this statute in New York allows for the survivors of that shooting and both those who lost their loved ones and those who were physically present, who were shot, who were traumatized, to bring an action against that gun dealer for that illegal misconduct. A final example, Glock has known for years that its pistols are easy to convert into machine guns. They have known from the jump, Gaston Glock himself not only knew that his pistol design was easily convertible into a machine gun, he had a device, a little switch that he would pop on the back of his and do it himself. Particularly in the last 5 years, that secret has been out. And our streets have been flooded with these tiny devices that convert Glocks into machine guns. Glock has known about this and has done nothing to block people from doing that. There have been no effective solutions coming from Glock to this critical public safety problem. And using this statute, the state of New Jersey and the city of Chicago have been able to go after those designs that Glock has been promoting throughout its history, and a call for Glock to change its design to prevent the conversion of these weapons into illegal machine guns. So in each of those instances, we have cases, some of those against dealers, some of them against manufacturers, where you have clear misconduct that wouldn't previously have been actionable or would have been really, really hard to build a case. And we have a clear path now to be able to do it, to bring accountability to the companies, to bring justice to the survivors, and to bring additional safety to the public to solve these problems. So here are just key takeaways and messages about what this policy is all about. There are a very small number of gun companies that are irresponsible. A lot of them are responsible, but the small number of irresponsible ones have a real competitive advantage because of the legal landscape, and they drive gun violence. They supply the majority of crime guns. It's too hard to sue them. And part of that is by design by the industry, and part of that are because of unfortunate consequences of the structure of gun violence and the lack of resources in communities that are most impacted by it. Because the worst companies have a competitive advantage, it drives a race to the bottom. And it allows for those worst actors, in some cases criminal actors, to stay in business and to continue doing harm to the public. And we deserve better. This legislation gives a path to doing that by holding those bad actors accountable, by making it clear that there is an avenue to sue them, by giving resources to do it, by making those cases more straightforward, to taking away those unnecessary procedural hurdles, to eliminate the kinds of free rides to harming the public that have incentivized bad behavior in the industry, to get justice to survivors, to get them the answers in court that they need, to keep the courthouse door open to them, and to end that terrible structure that incentivizes the worst behavior in the gun industry. So I'm going to stop there with my formal presentation, and would love to open it up to questions.
David, I want to start just by saying thank you for presenting us with all of this information, which is critically important. But one of the things that I'm always struck by when you do these presentations is that you help us not just understand what the policy is, but really how it comes to life and how it impacts people's lives. And I think that what I'm taking away from this is not just, the understanding of the policy itself, but the access to justice piece and how this relates to bringing more justice around this issue of gun violence and how it impacts so many people here in the Commonwealth as well as across the country. So thank you for all of that information. It's really a tremendous help to all of us in our coalition community. And I just want to remind folks, I would love for people to put any questions that they have in the chat. I also want to invite our other friend from Giffords, Joe Platt, who is the Senior State Legislative Manager, but has also been a tremendous partner to the coalition over the past few years, was super involved in all of the advocacy that led to the omnibus legislation getting passed, and is also really a part of our coalition community. And I'd love to have David and Joe just a part of a conversation with a couple of topics I wanted to bring up as well. And then we will be opening up to questions from all of our participants who have joined us today. The first question I wanted to pose to the two of you, David, you mentioned that multiple states have already passed similar policies. And I'd love to talk a little bit more about the strategy and what was learned in that process from these other states getting the policy passed and how we might learn from their experience and inform what we're trying to do here in Massachusetts. So any high level takeaways from what that strategy looked like in other states?
Yeah, absolutely. I think the strategy and the messaging has been adjusted and modulated in a few different instances as we've worked on these. And I think highlighting what the impact and the intention has been really important. So when people hear about this at first blush, they think of it as this is something that the trial lawyers are coming out to ask for. This is like a litigation-driven thing. There's trial lawyers want to have an easy avenue to make some money. And that couldn't be further from the truth. In none of the states has this been a trial lawyer-driven policy. This has been driven by advocates in the communities. But I think that's an important point in the first instance, because a lot of legislators have been conditioned, particularly by the defense bar, to say, whoa, 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 new litigation, like that's setting off alarm bells for me. And so I think getting past that piece, that this isn't just a defense bar, plaintiff's bar sort of thing. This is about access to justice for families who deserve it. And it has been a really important piece to highlight. Second thing I think I would highlight is that this also is not an attack on the gun industry. This is not trying to put gun companies out of business. One of the talking points we got hit with the most at the beginning was, if you pass this law, every gun dealer in our state is going to close down. You're not going to be able to buy a gun. This is something they use in New York. You're not going to be able to buy a gun in the state of New York if you pass this law. Now, that's not been true at all. Based on some of our research into what's happened since then, a state that passes this law as compared with a state that doesn't might see somewhere in the single-digit percents difference in the number of gun dealers that are operating in the state, the number of gun dealers that are shut down. And that's a good thing. we want to do here is we want to take those 5% of worst gun dealers off the books. We want them to stop selling guns. That's the goal here. That's not a problem. That's what we want to accomplish, is to get a very small number of bad actors to stop selling guns. And so that, I think, is a key message, that what this is about is not making it impossible to do business. And in fact, if you're a responsible gun dealer, this should be good for you. I mean, folks don't like to be told there's going to be a potential you might be sued ever. So they might not recognize that. A lot of gun dealers are not going to recognize that. But once this is in effect, it means that the responsible behavior that you've been engaging in because you believe in acting responsibly, you don't believe in harming your community, that's going to be something that you're rewarded for rather than penalized for. And so that's another point that I'd really highlight. The success that we've had has been in highlighting and putting forth, I think, first and foremost, victim stories. Not necessarily this person was harmed and they weren't able to get their day in court, but to explain what the circumstances look like when a survivor has experienced gun violence. And so the ability to put those stories forward isn't just about the very narrow sort of thing about, I tried to bring this lawsuit and then my suit was dismissed, because that's not what this is about. The other side tries to make it that, like, show me a case that was dismissed that should have gone forward. And there are those cases, of course, but that's not what this legislation is about. It's about the dozens and dozens and dozens of cases that never get brought because the people who are harmed don't have access to the resources and they can't get an attorney to do it. It doesn't pencil, it doesn't make sense. So the goal of this is to make those meritorious cases make sense and be able to be brought, not to harass responsible people, but also not to coddle wrongdoers either.
Thank you for that, David. It really also struck by the importance of messaging and making sure that we are getting the right kinds of messages out about policies like this so that folks understand really what the core values are that are attached to these policies. And that's part of why we're having this gathering today, is that folks can also not just hear what the policy is, but really why we are doing this work and the impact that it has. So anything that you wanted to add on that topic?
Yeah, I think going back to first principles, when you're thinking about, okay, I have a piece of policy that I'm trying to push forward in a state house, right? How do we do that? You got to teach people what the policy is, and really this conversation today is a part of that, getting back to square one of the basics of how you do things in a democracy, right? Um, so, we wanted to bring y'all together for David to share his expertise on this topic so that you all can go out there and talk about this. And we're going to reemphasize that a lot over the next 25 minutes that we have of this lunch and learn, that, the folks in this room, you all have done the work over the last 10 years, 15 years, even longer, to build the case to our champions about, say, background checks, right? Where the average legislator in Massachusetts could explain to someone why a background check is important to make sure that a dangerous person can't get their hands on a firearm, right? We have to build that foundation within this movement around this issue. So really going back to basics and just talking to the folks in your lives, talking to your legislators and stuff like that about this issue, getting back to that square one is really where we are. And you all have been doing that for years, so I know you know how to do that. And I think going back to your basics is really where we are and how we're going to get this done, just like we would any other legislative push.
Great, thank you. Moving on to another question, we've been referencing the omnibus legislation we got passed this past summer and how much Giffords was a partner in making that happen. And one of the things I also want to highlight is that in the aftermath of getting that legislation passed, Giffords gave Massachusetts an A grade for our legislation, which was very exciting. However, we always know that there's always more work to do. There's more that we can do to strengthen policies. There's more that we can do to invest in community-based solutions. There's more that we can do to bring our numbers even lower and to make sure that even more families are not impacted by the trauma of gun violence. And I would love it if you could talk a bit about how industry accountability, access to justice, this particular legislation will further strengthen Massachusetts' response to gun violence overall.
This policy, I think, maybe uniquely about everything that we advocate for, complements every other policy. And that's because it's not just about saying this gun is going to be prohibited or this process needs to be followed before you can obtain a gun. This is all about making it so that all of those other policies that we've passed and advocated for have avenues that they can be enforced. gun industry is notorious for ignoring laws in the books. That's a talking point we hear all the time, right? You should enforce the law in the books. And that's because a lot of the laws in books are not enforced. Why are they not enforced? Well, ATF, even before this administration, was hugely hampered, has the ability to inspect a small percent of the dealers that they have jurisdiction over inspecting. And usually when they find violations, they're slapping them on the wrist. We don't have an effective regulatory regime to be able to hold our gun dealers accountable. Now, we've made a lot of progress on that in Massachusetts, but guns don't stop at the border to Massachusetts. In fact, a very significant number of the crime guns in Massachusetts are coming from outside of Massachusetts. So what does the state of Massachusetts do when that happens? Too often, they're left without recourse. This policy is about making sure that there are clear avenues for accountability and enforcement of every law that we pass. And I think I come back again to ghost guns as being like the paradigmatic example of this. Okay, ghost guns are prohibited in Massachusetts now. There are companies out there that do not care. If you went online right now and you were trying to buy some ghost gun kits that are clearly legal under not just Massachusetts law, but federal law now after the most recent Supreme Court decision, you can still buy them. Why can you still buy them? Well, it's because nobody is taking the time to shut those companies down. And can the Massachusetts Attorney General do that right now? Maybe. But after we pass this, absolutely. And they have an avenue to do it. Can somebody who's been shot by one of these guns that was sold that should never have been sold do it? Maybe, but it'd be really hard. And this would make it a lot easier. So this is about making sure that we have an avenue to enforce every law that we pass and to make sure that the industry is complying with them.
That's really helpful. We talk all the time at the coalition about how there isn't just one policy that is going to solve gun violence. It's when we put together a suite of policies that complement each other that we really build up the safety net. And I think that's a great example of that very point. Another question, and then again, I want to encourage folks who are with us to put their questions in the chat so we can hopefully get to as many of them as possible. As other states have worked on getting industry accountability passed, I'm wondering what you have learned from survivors and what you've heard from them about the importance of moving this policy forward.
Some of the strongest advocates for this policy were a family, Sandy and Lonnie Phillips, who some folks may know, who lost their daughter in the Aurora, Colorado shooting. And after that shooting, they brought a lawsuit against the companies responsible for arming that shooter. And they were bankrupted, basically, by that case because all of the legal, in this case, substantive barriers that prevented them from being able to bring the case. Another example is after the Sandy Hook shooting. You had there a community that had been devastated by one of the most highly publicized and notorious mass shootings of all time. And they had a hard time finding a lawyer to bring a case. And that's because lawyers had it in their mind, you can't sue the gun industry. I mean, it's because of the federal substantive statute and because of the case law that the industry had built up behind that. It's also because of the difficulty of doing all those things, accessing the information, all the structural barriers that we talked about. And the only reason the Sandy Hook case went forward is because there was one lawyer in the state of Connecticut, his name is Josh Koskoff, who said, oh, I'm going to bring this case. Like, of course I'm going to bring this case. And the litigation experts would have told him this is a bad case. You're not going to win. And he said, I don't care. And he brought it anyway. And without that context, you don't get these cases. And so the vast majority of gun violence, we don't see these cases. The vast majority of survivors don't even know that this is an avenue available to them, let alone are they able to get past the 1,000 steps they need to do and to have a successful litigation. And so this is all about changing that process. And so the Koskoff law firm and the Sandy Hook families that represent have been strong supporters of this legislation in Connecticut. We're currently working on that right now. It's passed the Connecticut House. We're hoping it's going to pass the Senate soon. So it's active in Connecticut right now. Sandy and Lonnie Phillips were instrumental in getting this done in Colorado. You'll note that map that I brought up earlier. The kind of maybe not usual suspect in that collection of states was Colorado, and that was because of Sandy and Lonnie Phillips and the advocacy that they were able to bring and the clarity they were able to bring on this issue.
Thank you, David. That's incredibly helpful. I'm going to touch on a couple of questions that we either have in the chat or that have been posed to me. And again, just encourage folks to put any more questions that they might have in the chat. There was a question in the chat about forced reset triggers and a question about how that might impact Massachusetts.
Yeah, so if folks haven't seen, there are these devices, they're similar conceptually to bump stocks or the Glock switches that I was talking about earlier, in that they convert a semi-automatic gun to be a machine gun. That's just what they do. And the whole quibbling is, well, does that fit within the letter of the statute of what machine gun is? Because federal law defines machine gun as being a weapon that fires automatically by a single function of the trigger. So basically kind of an original sin back to when we passed the National Firearms Act in 1934, is that language, which was highly debated. People were going back and forth on it. And they ended up at this kind of awkward passive formulation, single function of the trigger. And they did that because they wanted to have an expansive definition that would capture everything out there. They didn't want to say pull of the trigger because what if somebody developed a gun that you push a button? So they said function, so they don't have to worry about pull versus push. And that got translated over the course of the almost 100 years since then into a bunch of different avenues where the industry tries to get around this statutory language. So basically from the jump, they've been doing that, trying to figure out ways to make machine guns that, because of one weird trick, aren't machine guns under federal law. Bump stocks were an example of that. We've seen trigger cranks, we've seen Hellfire triggers, binary triggers, bump stocks, dozens of these things over the course of years. And some of them you've heard about, some of them you haven't. And a lot of the reason is just because of the accident about whether that particular one was used in a high-profile mass shooting or not. But it's been a constant by the industry, in part because of, as we've talked about, the race to the bottom element. There's money to be had in doing this, and so the worst actors are going to do it. And the people who are the more responsible folks who say, I'm not going to try to figure out, like my precious time on earth to sell machine guns, they aren't, they're at a competitive disadvantage, the people who will do that. So anyway, we've got this new latest version of that old problem, is somebody trying to get around the law. Forced reset trigger. The way that they explain how this product works is you pull your trigger and then it snaps back. All triggers are going to have a reset on it. You pull the trigger back and then you release it. What happens? It comes forward with a certain amount of strength. The way the forced reset trigger works, the way they explain it, is it comes back with a ton of strength. It goes whack, whack, whack. And so theoretically, they say, if you're a shooter, you're going to pull back your trigger finger and the trigger is going to get depressed, and then it snaps back forward on its own and gets depressed again. So this is how this works. So from the perspective of a shooter, you pull back your finger and then it shoots until you let go or your magazine is empty. But from the perspective of the trigger, they say the trigger is still going back and forth. So because of the Supreme Court's decision on bump stocks, where it's kind of a similar thing, they said the trigger's going back and forth, so it's not a machine gun. There's not a single function. The trigger's functioning a lot of times when it goes back and forth. No machine gun, and therefore you can sell them. DOJ and ATF until last week had said, no, this force reset trigger thing is not working the way that you said it works. It actually is a total redesign of the gun. It's not just they swap out the trigger for this trigger that has a different reset value. They actually change the mechanics of the upper as well, and they take out the disconnector in the gun. The disconnector is the thing that basically allows for a semi-automatic weapon to operate semi-automatically. It stops the gun from cycling automatically. I've gotten too far in the weeds here, but the short answer is there were really good reasons to differentiate this from a bump stock. And DOJ was doing everything it could to win this case because they realized how dangerous these things were. And then they settled it. They said, nope, we're going to pull this back and you can sell these things now. And we're not going to call them machine guns. What does that mean for Massachusetts? Well, Massachusetts is one of 11 states that has a law on the books right now calling these things machine guns, making them illegal. So you cannot buy them in the state of Massachusetts, no matter what the Trump administration does. But of course, you can buy them in the state of Maine. So does this impact Massachusetts? Of course it does. Absolutely it does. And I think my real fear here, my greatest fear here, is that we're not just talking about an aftermarket product that could be the next bump stock. We are talking about that. But we're also talking about a product that could be installed on AR-15s coming off the assembly line. So it could be the case that you go into a gun dealer in the state, not Massachusetts, but in another state, and you say, one of your options available, you could get the AR that has the bayonet mount, and you get the AR that has the force reset trigger. So you could walk in and just buy a machine gun off the shelf. I think that's potentially the world that we're looking at. And it's a very scary world. But companies doing that, knowing that it's going to get sold in Massachusetts, we pass this law, there's an avenue to hold them accountable for it.
Appreciate that. And it really speaks to why, we've always known that what states do to respond to gun violence is incredibly important and possibly now never more important. So the way that we respond to changes in federal law, changes in technology is just critically important for us in Massachusetts to keep on working towards continuing strengthening our policies. So I really appreciate all of that information. Veering off into a different topic, because we got a question about the intersection with consumer protection statutes. So I just want to pose a question for you to touch on, as we have a consumer protection statute here in Massachusetts, which allows claims for unfair and deceptive trade practices and also provides for attorney's fees under certain circumstances. And I'm wondering if you can touch on how industry accountability and what we're talking about does interplay with that consumer protection statute. If there are any differences, and just help us understand what that looks like.
Yeah, it's a great question. Consumer protection statutes have been critically important in bringing litigation against the gun industry since the federal immunity statute was enacted, because that's a law in the books at the state level that you can point to. If somebody's violating, they should be held accountable for it. That was the Sandy Hook case. That was how that case was actually able to go forward. They brought a lot of different theories, and the one that survived and the one that they won on was a violation of Connecticut's consumer protection statute. There's something a little, well, the avenue though that case went forward on ended up being pretty narrow, because they had to make it about the consumer protection issue. Now, it was the greatest victory in this space, period, full stop. And what the Bushmaster had been doing there, the ways in which they were advertising, the kind of advertising they were doing, the toxic messages they were putting out, the way they were driving young people to violence was horrific. But it was only one piece of what they were doing wrong in that scenario. And that's the only piece they were able to hold accountable for. Because the consumer protection statute, you'd have to look at a way that they're deceiving consumers. So the theory in the Sandy Hook case was they're selling a military weapon to a civilian audience. They're misleading the civilian audience about the appropriateness of this weapon for civilian use. That's a small part of all the misconduct that was going on there. But it all had to be framed in that consumer protection version. So to give you another version, this ghost gun thing, companies selling ghost guns. To bring the action under consumer protection statute, what you're really doing is you're saying, by selling these things, you're misleading the buyer and telling them that it's legal for them to have this thing in Massachusetts. Now, that's a perfectly viable theory, but it's a little circuitous. What they're doing is they're selling guns that are illegal in Massachusetts, full stop. That's illegal. If they had a disclaimer there and said, this gun is illegal in Massachusetts, if you're in Massachusetts, don't buy it, and then somebody logged on, bought it, and they shipped it to them anyway, that should be actionable. The person wasn't deceived, but that is clearly breaking the law. And even if the buyer is colluding with it, I mean, let's do this extreme scenario. The buyer is an active gun trafficker, and they have an active handshake agreement with the ghost gun seller that they're going to take in 100 of these every week and then sell them out on the streets. That kind of conspiracy scenario, I mean, is that a consumer protection violation? I think you can make out that case. I would make out that case, but you shouldn't have to go through all those hoops, because it's an obvious violation of the law that should be directly actionable. And so this process is a way to do that. So at the end of the day, I think it's a complement, it's a supplement, but it's really a way to supercharge the ability to hold bad actors accountable without having to go through some more difficult theories that produce additional barriers to getting the accountability that we deserve.
Incredible. It's super helpful. Thank you. I have one more question. I also really was hoping Joe could weigh in on this as well, which is really about what's next. So we have a lot of folks here who are very eager to get involved with moving this policy forward, have been a part of our coalition community for a long time, and have also worked on legislative advocacy with us. And I know that folks are going to want to know what they can do to get involved in the work of moving this important policy forward. So if we can sort of think ahead and talk about strategy and how folks can get involved, that would be terrific.
Yeah, and I know that this is the perfect group to have this conversation with, because I just want to say thank you to everyone on this call for the work that I know everyone did in support of Ruth and I when we were in the State House working on the omnibus bill. That would not have happened without the folks on this call and so many folks off of this call who worked for a long, long, long time to get that done. So first of all, I just want to say thank you. Um, I sort of alluded to this because I just want to say it multiple times over the course of this call.
Thank you.
Talking about this issue is really our first barrier. Long before I started doing this work, like I said, I compare it to background checks, right? Folks did the work to build that foundation of support amongst our champions and then built out from there to build that broad base of support. So when you're talking about gun violence prevention, talk about industry accountability legislation the same way you would about an assault weapons ban, a high capacity magazines ban, a licensing law, stuff like that, right? This needs to be part of the conversation when you're talking to your legislator about what it means to pass strong gun safety laws in Massachusetts. So, reaching out to your state representative and your state senator and asking them to co-sponsor the House and Senate version of this bill. That is the number one way that we can show folks in the State House that this bill has broad support in both chambers. And that's how we're going to get this done. So the fact that you're taking time on a Thursday afternoon to sit with us and talk about this issue tells me that you're pretty engaged. I feel pretty comfortable assuming that. So reach out to your legislator and ask them to sign on to this bill. That's the number one thing that we can do right now.
Thank you, Joe. David, anything you wanted to add to that?
Joe said it perfectly as always. I guess the only other thing is, we're here as a resource. If it's helpful to like work through how to talk about this, if you just want to do a trial run with me, see how it goes. I mean, the problem with this issue is just, it's so in the weeds. It's like a very complex legal issue. It's a really simple principle at the end of the day. People who have done wrong should be able to be sued for it. And the people who have been harmed should get their access to the courtroom. But once you get into the Protection of Lawful Commerce and Arms Act, people's eyes glaze over. So we're available and eager to chat about the best ways to kind of talk about this with other people.
Great, thank you. And just even a couple more points. Part of how we know legislation gets passed in Massachusetts and anywhere else is by turning up the volume, getting lots of folks talking about a policy, advocating for it, working together, and joining voices in unison to make sure that legislators know that people care about this policy. And today is a big step forward in helping to turn up that volume. And one of the things that we'll be doing at the coalition, we'll follow up with all of you. We'll have a recording of today's session. We'll have some fact sheets that folks can use to learn more about this issue, as well as some more next steps around co-sponsoring and other things that we can do to make sure that the folks at the State House know there's a large group of people in Massachusetts that care to make this policy move forward. So stay tuned for all of those details. For now, I want to finish with gratitude. I want to thank David and Joe for being incredible partners to the coalition and all of us in this work, for bringing this important information forward and explaining it in a way that really, I think, helps all of us grab on to not just what the policy is, but why it is so critical to bring more justice to the world that we move this forward. So if we can all just take a moment and appreciate David and Joe and all of the work that you did to prepare for this and to partner with us, just want to say thank you.
That's really very kind, Ruth. It's our absolute pleasure to be able to partner with you in this important work.
And lastly, I just want to appreciate everyone on the screen today for spending time with us and being a part of this incredible coalition community. We could not do this work without all of you. So thank you for being with us. Stay tuned for more information, and we look forward to seeing everyone again really, really soon. Lots more work to do. Thank you.
Thanks for taking the time, everyone.